Okay, hello everyone. So this is the missed session for our lecture on the 6th of February. I'm recording the lecture here and I'm going to upload it so you can view it at your leisure and you can view it in your own time. I want to apologise that I wasn't able to make it to the session. I'm delighted that Randy and Fuat were able to run the session without me. That's fantastic. And thank you all for doing that and for being committed and for engaging with the process. That's excellent, and I feel like my work is done, so that's great. And I look forward to seeing you all on Wednesday. So let's get started. Let's cover crime and piracy. So as you know, we've got Eleanor and Zafer and Usami who are going to cover this next in the next seminar. They've got some great materials. You can see on the seminar handout we've got some really interesting articles. I'm really looking forward to reading those and some really interesting questions. So I think we've got plenty to discuss and a really interesting topic area. Unfortunately, while it's a really interesting topic area, the law is quite dry, of course, in the sense that it's there's certain strict rules about what you can and can't do. I wouldn't say it was dry, but the law is complex, I suppose would be a better way of putting it. So let's first go through the different zones. So as always, the further you go out, the less sort of coastal state control you have. So in the internal waters, coastal states obviously have full sovereignty. It's effectively like you're inside their land. It would be the equivalent of pulling a ship into into an internal bay or into the estuary or something here in the UK. So generally, you're bound then by the law of the coastal state. But obviously, if something happens on board the vessel that doesn't disturb the coastal state, some internal maybe a fallout between the crew on the vessel, but it doesn't affect anyone on the land, then it's up to the coastal state. But they generally won't exercise jurisdiction. They might just leave that to be resolved by the crew or by the flag state. And that depends. Obviously, sometimes the captain of the ship may request assistance, or there may be a time when it may disturb the peace, or it may be of such a certain nature, perhaps a serious crime or something, where it would be considered to disturb the peace. Same very much for the territorial sea. So the next stage out, we go up to 12 nautical miles. The territorial sea is similar. It says under Article 25 that coastal states may take the necessary steps to prevent passage which is not innocent. So we talked about innocent passage previously, but this is passage which is prejudicial to the peace, good order, or security of the coastal state. So that sort of overlaps a bit. It's saying that you can pass through, that's okay, but if you're doing anything that's going to interfere with our rights, our interests, or that's going to interfere with the good order or security of the state, then we have the right to, take enforcement measures, and that would include boarding and seizure and all the sort of powers that would come with enforcement within the country. Similar sort of thing in terms of criminal law jurisdiction. Criminal law applies. But again, where it happens on the vessel, states may not, they may decide not to exercise jurisdiction unless it actually disturbs the peace of the coastal state. So something internal to the crew of the ship may not be something that they would interfere with. But generally, any sort of criminal activity that the coastal state will detect, it's possible that it will exercise jurisdiction. Now, the contiguous zone, as we all know, is a special zone. So we've got 12 nautical miles for the territorial sea. Then we have another 12 nautical miles, up to 24 nautical miles, out for the contiguous zone. And this is a special zone for criminal matters, mainly, really. It's for criminal jurisdiction. And what it does is it provides the coastal state with the opportunity to enforce its customs, fiscal, immigration, and sanitary laws out to that distance. So it's important for either chasing somebody who's breached those laws, or arresting somebody who's breached those laws, having been in the territory of the state or been in the territorial sea and has since left. You might catch up with them and arrest them, or it can be for preventing those laws from being broken upon entry into the territorial sea. So perhaps a vessel that's carrying materials that need to go through customs, or drugs or narcotics which shouldn't be brought into the country, whatever it may be. It gives them enforcement power to go out and arrest vessels and seize them before they actually come into the territorial sea. Moving out now to the next big ones, the exclusive economic zone and continental shelf. As you know, they're sort of run in parallel in a way. Here, the states have criminal jurisdiction over things that are much more related to their resources, which makes sense. So these zones are they're meant to be like the high seas, but where the jurisdiction is focused on the resources and the exclusive rights of the coastal states over their resources. So the idea is that any jurisdiction that a coastal state exercises in these zones must be related to their resources or the exploitation of their resources. So that therefore includes obviously things like pollution and environmental law, where the coastal state will have a lot of interest in enforcing jurisdiction over here, because it will affect their interest in their resources, it will affect their interest in conservation and protection of their environment. And obviously that includes things like fishing as well, so fishing laws and so on and so forth. It has quite a lot of information about enforcement over fisheries. And that also includes jurisdiction around the safety zones around structures. So we talked about that in our last lecture, about sort of maybe oil rigs or islands that might be built, and you have also some jurisdiction around those. And then right out in the high seas, states effectively, it's mostly run by flag state jurisdiction. States are left to independently run their own vessels. Vessels don't tend to interfere with each other, but there are exceptions to that. The major exception is the right of visit under Article 110, and this is for arresting, boarding and inspecting, and then potentially arresting, depending on what it is, but certainly boarding and inspecting any vessels that are suspected of piracy, slave trading, unauthorized broadcasting, or effectively being stateless, i.e. they are roaming the seas but they don't actually have a flag, so they're not being governed by any flag state, which obviously brings them outside the law a little bit and means that they are effectively operating without any kind of legal oversight. So on top of that, they have certain rights to arrest and seize ships that are engaging in certain activities. So that would be piracy, slave trading, and broadcasting again. So Article 10 gives you the right to visit and inspect about these things, whereas other articles give you the right to actually arrest vessels that have breached those rules. The right of hot pursuit as well under Article 11 means that although you don't have jurisdiction in the high seas to enforce certain crimes, what you might have is jurisdiction in the contiguous zone, or in the territorial sea, or in the internal waters, or in your exclusive economic zone. And if you detect somebody has broken rules in one of those zones, broken the law, and you then pursue that vessel, you can continue to pursue that vessel into the high seas and arrest it in the high seas, and that's perfectly legal because you have stayed in pursuit of that vessel. So we'll be discussing hot pursuit in the next seminar, which will be very interesting, and I will talk about it again a bit more in a moment. So effectively, access to ports and internal waters, I think the point is here that the coastal state will exercise jurisdiction to effectively protect itself, but generally a lot of port states have agreements that allow them to move freely between ports, and unless they've actually got any suspicion of anything that needs to be inspected or arrested, they will just allow vessels to come in and out. So they don't tend to discriminate between vessels, and they tend to have these bilateral or multilateral agreements that allow for access to each other's ports. Okay, so conducting arrests. So there are specific rules on how you actually arrest vessels. So that would include how you interdict the vessel, how you might board the vessel, and how you might carry out any inspections before then conducting any arrests and so on. So in general, there's a requirement that you've got to be careful not to cause any hazard to a vessel or expose anyone to any unreasonable risk when conducting arrests. So what that means is you've got to think, you've also got to always have an eye on safety. You can't go charging in and bashing into a vessel, or trying to arrest somebody in severe weather when they're maybe in distress or whatever it may be. You've got to focus first and foremost on safety, and that includes trying to board a vessel, not coming in perhaps. Say you've got a much larger vessel and you're trying to board a smaller vessel, being careful not to collide with them and so on. So again, that also applies with arrests in the territorial sea and contiguous zones. So you've got two things here. You've got the main one under Article 225, seems to apply across the whole convention, because it says in the exercise under this convention of powers of enforcement, even though it's in the section on environmental protection, it says under the whole convention, so it's generally presumed that applies across the board. But you've also got a similar clause in Article 27 with regard to the territorial sea. Related to this is the question of whether states can use force, and to what extent the use of force is valid. And this was discussed in the MV Saiga case. Remember, we discussed this case before, and comes up quite regularly actually. And it was talked about how international law applies by virtue of Article 293, which says that the general rules of international law apply. And here the tribunal suggested that general international law would include a general rule against avoiding force unless it's unavoidable. So, not using force and not going beyond what is reasonable and necessary in the circumstances. So effectively there's a balance there, but you can't use force unless it's absolutely necessary. An important thing to remember in all of this is that a lot of these arrests, they kind of each, in many cases, in most cases for each area of jurisdiction, it provides that it needs to be carried out by officials of warships or military aircraft or other ships or aircraft clearly marked and identifiable as being on government service and authorised to that effect. So this is the point here, that they're identifiable as on government service and they're authorised. So they've got to be proper vessels. So it might be, more commonly, it would be your Coast Guard units, it might be your police and maritime police units, and it might be, often it will be your naval or your military units as well. So effectively, your government enforcement units rather than private operators or anything like that. And they've got to be clearly marked. So the Coast Guard would clearly have some markings to say that it was the Coast Guard, or if it was a military vessel, often they'll have flags that will indicate that it's perhaps a part of the country's navy or something. So it's clearly identifiable, and only those vessels are able to carry out these arrests. And in most of the areas where this jurisdiction is given for enforcement, here, for example, on pollution laws in the EEZ, carrying out hot pursuit, the right of visit on the high seas, any seizure of pirate ships, and outside of UNCLOS as well, there are also many other agreements where they bring in the need for government authorised vessels, such as arresting illegal fishers under the Regional Fisheries Management, under the UN Fish Stocks Agreement, within the Regional Fisheries Management organisations. So if you're going to be arresting illegal fishers, you also need to make sure that you're using a government authorised vessel. So there's some uncertainty whether all arrests should be carried out by state authorised vessels, because it seems that most of the sections, as we pointed to in the last section, actually seem to specifically say, whereas there's a few areas where it's not specifically said whether you should exercise, whether it should all be carried out by government authorised vessels. And it was suggested by the International Tribunal for the Law of the Sea in the MV Virginia case that, again, international law would apply, and that would suggest that arrests are carried out by authorised and clearly marked government vessels, because that seems to be a general customary requirement of international law. So there seems to be this generally widespread view of this, but not everyone agrees. Some have disagreed with this, because there's nowhere in the UN Convention where it actually says that all arrests need to be carried out by government authorised and clearly marked vessels. Only is those specific sections that were pointed to. There are certain areas where you might have the right to arrest, but you don't need to use a clearly marked government vessel to do so. But I think that's an open point, one for discussion, and I think the tribunal have certainly made their initial views known. So on that point, here is the white ensign, for example, of the British Royal Navy. I thought it was an example of um, the markings, the clear markings of a government authorised vessel. So this is the HMS Queen Elizabeth, the the aircraft carrier, of course, and that's the flag to identify that it's under the flag of the British Royal Navy. So that's an example of a sort of marking that might indicate to other vessels the authority of the vessel. So there are rules also, a bit technical, we don't need to worry too much, but about how you need to often need to inform flag states of arrest. For example, if you arrest any vessels in the territorial sea or contiguous zone, then you are expected to notify the flag state about that, and to keep in touch between the flag state and the crew. And similarly, if you arrest any vessels in the exclusive economic zone for fishing or for pollution, then you need to notify the flag state and let them know of any vessels of theirs that you've arrested and any penalties you're imposing. However, there doesn't seem to be any equivalent provisions in other parts of the exclusive economic zone or continental shelf. So only for fishing and pollution, but it doesn't seem to be that any other environmental offences that might occur in the exclusive economic zone, not environmental offences rather, but offences relating to resources, may not necessarily require you to notify the flag state. We don't know. A useful thing to know is that there is a system for prompt release following the arrest of a vessel. So what this is that in the case of, for example, arresting a fishing vessel for illegal fishing under Article 73, once you've seized that vessel and brought it back to port, you are required to release the vessel once the flag state has posted, or somebody has posted a reasonable bond or other security for the vessel. So what that is putting some money into a third-party account and saying, look, we'll put some money there, and that's a security, so that if ever there's a court case and we lose, there's some money there to bail out, to pay out the to pay out on the award. So so that is often used as a system to allow for the release of vessels. And there's a requirement to use it for the case of fishing, but there doesn't seem to be a requirement to use it for other areas throughout the Law of the Sea Convention. And for various things, it seems that it's up to the coastal state to determine the rules for release of vessels and seizure. But generally for environmental offences or offences in the exclusive economic zone, there is a requirement for prompt release following the posting of a bond. And this was interestingly discussed recently in the Volga case. Well, it wasn't recently, but relatively speaking, recently. In the Volga case, where Australia tried to impose a requirement instead of a bond, it also wanted to put an electronic tracking device on the vessel and said, look, we can let you go, but as long as we can put an electronic tracking device on you so that we can always keep an eye on where you are, and it'll be easy for us to bring you back. And the International Tribunal disagreed with this and said that it's quite clear that the wording in the convention refers to financial security. So they were kind of taking quite a literal interpretation there, and didn't like the idea of including sort of an electronic tracking device. So, as I mentioned before, it doesn't seem that prompt release applies to other areas across other maritime zones. There's not clear rules on this. There has been some discussion, but generally, customary international law would suggest that you do need to allow vessels to continue their work unless they've been engaging in some serious crimes and so on. So it's one for discussion. There has been academic discussion on that. It does also seem that there could be an angle whereby you could ask for provisional measures And it could be that through asking for provisional measures from the tribunal, so under the rules on dispute resolution, you can apply to the say the International Tribunal, the International Court of Justice for provisional measures, and what that means is the court or the tribunal will, in the interim, put something in place to help, solve the parties' problems up until they make a judgment and they can do a more, a more forceful order. So it's sort of an interim measure, really. And one of those interim measures could, of course, be arranging for the release of a vessel and crew upon the posting of a reasonable bond, and that's what happened in the Arctic Sunrise case. They said that a provisional measure, a sensible provisional measure, would be the releasing of the vessel and crew for a bond. So it is clear that this use of bonds can apply outside of the arrests for just for pollution and fishing offences. So, right of visit. So we talked about the right of visit on the high seas. This is the opportunity for government vessels to intercept and to board and inspect vessels that they suspect to be engaged in a very specific list of activities. One is if it's engaged in piracy, one in slave trade, one is unauthorized broadcasting, the other is being without a nationality, and the other is a rather obscure one that says that it's not showing its flag, but in reality it's the same flag as the arresting ship. So in terms of unauthorized broadcasting, we don't need to worry too much about that. It was a particular problem back in the 60s, 70s, and 80s, where you had lots of pirate radio, where you would get pirate radio stations that were set up on oil rigs or set about at sea, and they were broadcasting into countries, but overcoming therefore that country's laws on radio airwaves, breaching laws, for example, about copyright and so on. Less of a concern these days because it's generally been stamped out, but that's why it's there. Slave trade still exists in many senses. In many senses indeed, particularly human trafficking. So it depends how you define slave trade, but yes, so that's also relevant still, but that's always historically relevant and will continue to be so, as is piracy. Has been around since ancient times, and piracy is still rife today. So we'll discuss piracy in a minute and what that is. And ships being without nationality, so we'll also look at that in a minute as well. So once a warship has intercepted a vessel on the high seas and it's carrying out its right of visit, it's effectively where the ship has suspicions about any of those acts being carried out. It then has authority to check the documents, and if their suspicions remain, then it has authority to inspect the ship. Obviously, the risk is that if the suspicions prove to be unfounded, they may have to pay some element of compensation to the ship that they've intercepted and put through quite a lot of distress, obviously being inspected and so on. So there may need to be some compensation, particularly for time lost as the vessel has been held up. So that was about the right of visit. Now about the hot pursuit, the rule of hot pursuit. I won't read out all this text. But the general gist is that, again, you can see here, hot pursuit needs to be carried out by government authorised vessels. And the main point here is that it allows states to leave certain zones, so their internal waters or archipelagic waters or territorial sea, wherever it may be, and they may continue to pursue vessels and arrest them as soon as they eventually catch up with them. And its important point here is that the pursuit is only valid if it's not been interrupted. So it needs to be continuous, and there has been discussion about what that means, but it does need to be continuous, and there can't be a point at which there's a break. And it also can continue from the EEZ and continental shelf as well. So piracy. So we often think of pirates. Of course, we always say this. We often think of pirates as your sort of Captain Jack Sparrow or whatever it may be, your sort of swashbuckling pirates of the past. And in some senses, there are. Everyone says that's all a fantasy, but yes, it's a fantasy. But there are some truths in that. There were lots of pirates of the Caribbean, and there certainly were. They certainly were characters. quite whether they're the Hollywood characters is different. But certainly, as we all know, we also have piracy today. These are modern day pirates, the kind of pirates you might see, for example, off the east coast of Africa. But this is just an example. Of course, piracy also happens a lot in Asia, and can continue around the world. So, piracy is a major crime. Obviously, we'll be discussing piracy in the next session, and it's widely understood to be it's one of those crimes that is of jus cogens. It means it's sort of everyone agrees that it's of such a reprehensible nature that everyone should have jurisdiction over it. So all states are expected to cooperate towards the suppression of piracy under Article 100, and all states have jurisdiction to arrest and seize pirate ships under Article 105. So that's the question of whether there's universal jurisdiction, and we'll be discussing that in the seminar. So then you question what's pirate ships. Well, Article 103 says it's a ship or an aircraft because it is intended by the persons in dominant control or use to be committing one of the acts referred to in 101, or if it has been used to carry out one of the acts in Article 101. So then what's Article 101 say? Well, this defines piracy as any illegal acts of violence or detention or any act of depredation committed for private ends by the crew or the passengers of a private ship or a private aircraft and directed on the high seas and all exclusive economic zones against another ship or aircraft, or against persons or property on board such ship or aircraft, or against a ship, aircraft, persons or property in a place outside the jurisdiction of any state. So it's across the high seas, across the exclusive economic zones, or anywhere else outside the jurisdiction of any state. So looking at that, I'm guessing it would refer to space as well, or anywhere else. It also includes any sort of participation in that or inciting any such activities. So again, where it's arrested but there's no reasonable grounds and it was incorrectly arrested, then there may be compensation. And again, it must only be carried out by government vessels. But of course, there are difficulties with enforcing against piracy. How do you suspect piracy? There are rules on making sure that you only board vessels that are clearly suspected of piracy, so you need to have good evidence of that. And also, once you actually arrest a vessel, how can you prove that the people on board were actually about to engage in piracy? Often, for example, if you arrest a vessel that has pirates on it, you'll find that they're often throwing their firearms over the side of the ship before they get arrested, so that when you get on board, they say they don't have any weapons, which is why they now try and film them very quickly to make sure that they capture on camera the act of throwing weaponry over the side of the boat. But there are other practical difficulties as well. Somebody's got to arrest that pirate. And prosecute them. So there's got to be some elements of taking those pirates back to some country that will effectively prosecute them. And there becomes the difficulty in the sense that a lot of states don't have very effective laws, very effective domestic laws, and might have poor resources and may not have the ability to properly carry out a proper investigation, carry out a proper prosecution, and as importantly, to actually effectively imprison any pirates and provide for long-term rehabilitation and so on and so forth. So very often they just get dumped back or dropped back on the coast of, say, Somalia, and there's not really a lot you can do. So there are difficulties there with that as well. So that's piracy. The other issue that is important is stateless vessels, and this is a very important one because this gives actually warships operating on the high seas and anywhere actually, not just on the high seas but anywhere, quite a lot of freedom to arrest or certainly board and inspect vessels that don't appear to have a flag. And that can be very important because it also, under Article 92, means that if a state has more than one flag, then you can also treat it as stateless, as effectively a stateless vessel. And this is where your right of visit comes in under Article 110, where you have the right to board and inspect vessels on the exclusive economic zone and high seas, which are suspected of being stateless, and that would include, therefore, under Article 92, if they have two flags. For example, it's quite well known that some vessels might actually pretend to have multiple nationalities, and they may conveniently put up any flag that suits them as and when they're being, being viewed from a distance. They might purposely use a certain flag to make themselves look like one nationality, when in reality they're travelling under different nationalities. So if that's detected at all, they would be treated as stateless, and they can be boarded. And what's important is that on this point here is, if you're stateless, you don't have a flag state. You're not registered anywhere. So you don't actually have the protection of the laws and rules that flag states get. And flag states have certain rights. They have the right to freedom of navigation and so on. But you wouldn't have that. It's quite a difficult area to know really what kind of jurisdiction you have against stateless vessels. Again, a lot more academic research needed here. Nobody really knows. Generally, the idea is that that they are subject to the jurisdiction of the arresting vessel, but they still have some residuary independent jurisdiction themselves, maybe from the owner of the vessel or something like that, because they can't be effectively immediately outside of the law and subject to the exclusive law of the arresting vessel. And they must have some additional protection. There must be some sort of jurisdiction that's already operating over them. But it's one for debate, and certainly one to think about. So we're moving on from the sort of more technical stuff. So we've looked at hot pursuit, we've looked at the right of visit, we've looked at how you conduct arrests and all those sorts of challenges. So now we're moving on to some of the more specific sorts of crimes and the sorts of different issues that we can face. And I didn't cover them all, but just some examples. So obviously a big one is drug trafficking. So this is a big seizure of a huge load of, I don't know, it looks like cocaine, I guess. But you get lots of these images of all sorts of huge hordes of drugs that get seized. This is quite small in comparison to some of the pictures, but still a huge amount. So similar to piracy, all states have to cooperate. I personally often critique the word cooperate. What does that mean? But I think it generally tends to mean that states need to continue engaging in bilateral and multilateral treaty negotiations, need to keep engaging in new processes of bringing in new legislation and negotiating new systems and rules for improving enforcement. But the main thing to mention with drug trafficking, as with a lot of these crimes, is that it still remains a flag state issue. So you can't just arrest another state's another state's vessel if you suspect them of engaging in drugs, trading drugs, if they're outside of your territorial waters. I mean, obviously, if they're inside your territorial waters, inside your territorial sea, then of course they're that's not going to be innocent passage. They're breaching your criminal laws, and so on and so forth. So you'd have criminal jurisdiction. But once you're outside there, basically it's only your own flagged vessels that you can arrest. So any state which has reasonable grounds for believing that a ship flying its flag is engaged in illicit trafficking of drugs may request the cooperation of other states to suppress such traffic. So it sort of very much hinges on flag state enforcement again, and as we know, that can be problematic. Some flag states are not so effective at enforcing, and many of these vessels are operating, on the other side of the world. So one system that was added by the 1990 Convention against illicit traffic in narcotic drugs was that if you suspect another vessel of engaging in drug trafficking, what you can do is you can request from the flag state of that vessel whether you can have permission to board it and to inspect and arrest the vessel. And it can work quite well as a system, because even though these countries are on the other side of the world and not really engaged with what their vessels are doing, generally if you are a navy from another country and say, look, we suspect that this vessel is engaging in illegal activity, there's often you can approve that, and there might be to your advantage to approve that and allow the arrest to take place. So that's well, I would assume that's improved it, but again, more research is needed. How effective has it been? All this stuff needs better research, of course. So moving on from drug trafficking, then there's obviously issues of environmental crimes, so illegal fishing, illegal dumping, anything related to stealing resources. Um, and this is, of course, as mentioned earlier, sort of mediated with the requirement to release vessels after a posting of a reasonable bond. So it recognises that there are environmental crimes, that these ships should be allowed to return back to sea, but there should be some financial security left behind. And we talked again with the MV Saiga and the MV Virginia case; they seem to come up a lot. Um, we've talked about the boundaries of exclusive economic zone offences, and in this case, in the MV Saiga case, they were bunkering oil; they were giving fuel to legal fishing vessels, and that was found to be okay and not a breach of the environmental laws of the exclusive economic zone. But in the MV Virginia case, they were giving oil and fuel to illegal fishing vessels, and that was found to be an illegal activity in the exclusive economic zone. So it's quite interesting. There's going to be future cases around, resource-related crimes, and at what point are you actually breaking the rules with regard to the exclusive sovereign rights of the state over resources in the exclusive economic zone? Um, Same thing with challenges of enforcement for illegal fishing and so on. It's very much on the flag state to do a lot of the work, and it's very difficult to achieve effective inspection of each other's vessels, particularly on the high seas. So this was addressed in the UN Fish Stocks Agreement that encouraged um, regions to cooperate together and allow each other to inspect each other's vessels and to give each other sort of jurisdiction over one another's vessels so that they can inspect and board each other. But of course, that doesn't apply to anyone who's not a part of that regional agreement. So improvements being made here against illegal fishing, but obviously there's always little ways around to get through the net, so to speak. And we'll cover about pollution offences in the next lecture, so we don't need to worry about that now. So, as you're all aware, if you've been watching the news, a huge problem at the moment, a very sad problem, is of course the issue of mass migration by sea, the difficulties of migrant smuggling, and of course, slightly related but a different matter is human trafficking, which is still an act going on today and still um, as heinous as ever, of course. So it's a controversial and difficult area, and again, more academic research is needed. And I think we're going to have a discussion about this in the seminar. Very important. It's in the news at the moment a lot, and it doesn't seem to be clear what's the best way to deal with this. And obviously, different people have their different political views as well that come into this. Generally, though, we are bound, quite rightly so, by international humanitarian requirements, which requires all states to make sure that they look after people who might be threatened, particularly in their home country. They can't just deport them back to their home country if there's a chance that they might be subject to torture or any other inhumane treatment. So you've got to make sure that people's freedom isn't threatened and they're returned to the right place. So you've got this contradiction because under maritime legislation, you've got a requirement to rescue vessels in distress. And if you see a vessel that looks like it's, if you see a dinghy that's out in the middle of nowhere at sea and it's bobbling up and down and it's got, women and children in there and people who are, not properly prepared, then they're clearly a vessel in distress. They're clearly a vessel that's not safe in terms of navigation. So you feel you are obliged under maritime law, obviously, to provide assistance and to rescue them. But then you have that conflict with the requirement of international humanitarian law, which requires you to, well, for example, here also, for example, under the maritime legislation, it requires you to deliver them to a place of safety. But under humanitarian law, you can't return them to places where they might be where their freedom might be limited or threatened. So effectively, the issue of refugees and making sure that refugees are given proper sanctuary. So then this becomes a challenge because you need to rescue them, but then where do you take them? And that's what happened in the MV Tampa incident. And obviously it's an ongoing issue still now, particularly in the Mediterranean. So for this reason, a lot of states are trying to address this. They're trying to get to the source of the problem. And that's why they're focusing on migrant smuggling, because what they're finding is that a lot of these vessels are being operated by people operating on the coastline who are actually trafficking a lot of this. And if you can get to those people, then perhaps you can prevent these vessels from leaving in the first place. And a lot of countries like the United States, the EU, and Australia have been introducing more legislation to try and control this. And similar sort of thing with narcotics earlier. They have a system of requests now, so that under the 2000 Protocol against the smuggling of migrants, if you suspect a vessel to be engaging in migrant smuggling and to be bringing migrants across to another country through by some means of exploitation, then you can request from the flag state, if it's not under your flag jurisdiction, permission to board and inspect and arrest the vessels. But again, this doesn't solve the problem of one's international humanitarian obligations, because obviously once you've boarded a vessel, if it's got lots of migrants on board, you then need to consider their safe return to somewhere of safety. And also this ties in with slave trading vessels, any vessels that might be trafficking humans or taking people under capture. Then the Article 99 says at any point that you arrest a slave ship, all the slaves are automatically free, which is quite an interesting rule. So that sort of ties in as well with the concept of human trafficking. So terrorism, this is the Achille Lauro. It was subject to a terrorist attack many years ago, and it's an example of terrorism that can happen at seas. It was hijacked, and the Palestinian Liberation Army, I believe it was, or it was certainly Palestinian terrorists were demanding the release of certain prisoners and so on. So terrorism is obviously something that is relevant in the sea, just as it is as it has been everywhere else, and particularly following the 9/11 attacks, the United States was very much sort of driving forward international developments towards strengthening protection against terrorism at sea, and particularly things like weapons of mass destruction and so on as well. And so a big part of this was the development of the International Ship and Port Facility Security Code, the ISPS code, which has been brought in through the IMO and which has sort of harmonized requirements for ports across much of the world and brought in procedures for inspecting and looking at vessels that come into the port and making sure that any vessels that perhaps might portray a certain risk are inspected more carefully, and to be careful effectively to prevent any weapons of mass destruction being brought into countries. So it's basically just a stricter form of checks at ports for terrorist activities. Similarly, the SUA Convention, the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation. This was many years ago, but it was amended in 2005 to be made much more in line with current issues. It very much talks about things that look like terrorism, seizing control of ships, committing acts of violence, destroying or damaging a ship in a way that would put it in danger, placing on a ship a device or substance which is likely to destroy or damage the ship, interfering with the ship's navigation facilities, or whatever. This is sort of your hijacking and terrorist type scenario. And again, the same system of requests. So even though you don't have jurisdiction over a certain vessel, if you suspect it to be carrying out any of these activities or be potentially about to carry out any of these activities, you can request permission from the flag state to interdict the vessel and inspect it and potentially arrest it as well. So it's interesting to think, just a random point as well, again, more research is needed because nobody's really researching a lot of this stuff, but we have a lot of private enforcement and self-defense going on at sea as well, because of course military vessels can't do it all, public enforcement isn't doing it all, generally a lack of resources, a lack of effective legislation, whatever it may be. So here's some water cannons that are installed on a cargo ship. It's quite common now for large sort of cargo ships or vessels that might be carrying anything of value, particularly if they're passing through somewhere that's a well-known pirate sort of area, such as the Gulf of Aden, or somewhere off the sort of Horn of Africa, or somewhere in the Straits of Malacca, for example. So certain places where anti-pirate devices are more important. We've mentioned, you've seen previously about the Sea Shepherd Conservation Society. This is one of their ships, but that's an example, a bit of the sort of private enforcement. And these are private mercenary units as well. Lots of cargo ship operators and vessels now hire their own effectively private armies, and on the seas you're getting a lot more private armies being hired to prevent any sort of illegal activity or any arrests or any hijackings, and to increase enforcement. So it's interesting that there's a sort of a privatization of power and defence going on the seas. Okay, so I'd like to just spend the last few moments just very quickly thinking about technology and how technology has become very important in the fight against crime and piracy on the seas. So, for example, a huge change that's come in just in the last 15, 20 years, particularly in the last 10 years or so, has been the use of vessel tracking. This has become quite substantial now. The International Maritime Organization has introduced compulsory tracking for vessels that are over 300 tons or vessels that carry passengers, and there are certain other sort of vessels that come under the list as well. And they have two forms of tracking as well, which are required. One is LRIT, so that's long-range identification tracking, and automatic identification system tracking as well. So they basically have transponders that are installed on the vessels, and they record through satellite or through radio waves the location of the vessels and so on. And it has actually led to a dramatic change in how we can monitor vessels. And obviously, if you come across a vessel that hasn't got its transponder properly installed, then obviously it's breaking the rules on that. So usually when they're inspected in port, you make sure that their transponders are properly installed. And it means that most vessels now operating on the seas that are of certain size, certainly not smaller vessels, are being tracked in a lot of cases, and they could be monitored. Now, I really wanted in our seminar to show you this website, Vessel Finder. It's just an example. There are several. I'll show you some pages quickly. So here is the screen on Vessel Finder. I'd love to actually show you all the actual website. I recommend you all go and look at it. But it's great fun. It's showing you in real time all the ships that are operating around the world. So here we are, obviously around the UK, around Europe, and all these different colours are indicating what kind of ship it is. So if it's like a yellow sort of triangle, it's a cargo ship. And if it's, I think if it was small and red, or is it a blue dot or something, it's a fishing vessel and so on. So they've got these different types of vessels, and every single one of these is identifiable. You can click on them, you can zoom in, zoom out, you can follow them as they move across the water, and you can click on them and it will tell you about the vessel, where it's registered, and all about it. It usually gives you a photo. So if we go in a bit closer, here we are off the coast of Exeter. I looked at this earlier on when I was when I was setting this up earlier today, and this is just an example. You would be watching these in real time. You can float over any of these and you can look at information about the vessel. All of these are mostly cargo ships going in and out of the channel, so they'll have travelled up either to somewhere in the UK, or they might have gone into the Baltic Sea, or they might have gone to Holland or up to Norway, or from Dover, Calais, wherever it may be. So there's a fair amount of traffic, as you can see, just off the coast of Exeter, which is really interesting to look at. So yeah, I do recommend you go and have a look. Here I've highlighted the Amber Spirit. It's registered in Barbados, but there's another cargo ship here, for example. So yeah, do have a look at vesselfinder.com. There are loads of these AIS sites now because this is all in the public domain. So there's quite a few websites that produce this sort of data, but this is quite an easy one to use. And yeah, I recommend you go and have a look and have a play with it. But that's just an example of how technology can be used, because what you can do when you use that sort of tracking is you can actually watch vessels and watch their activities. So if you see a vessel, for example, going up and down in lines, in tracks like this, then you know that that vessel is probably engaging in some kind of dredging or trawling, because it's going up and down like a lawnmower on a field. So you can watch the vessel, and if you see suspicious activities, you can know that. Or, for example, if you know that in my field you have underwater cultural heritage, so you might know that a wreck is in a particular location, a particularly important shipwreck. Well, if you see a vessel come over that wreck and sort of hover or linger for long periods of time, maybe days, or certainly hours at a time at those particular coordinates, then that might indicate that the ship is engaging in some diving or some surveys or some engaging in something over that site. So you can actually monitor the activities of the ships, and that can really improve security and technology. Again, against illegal fishing as well is a really important one. And technology is really improving things and making big changes. So here we've got an aerial drone. These unmanned sort of aerial vehicles are making a huge difference. They cost a fraction of actually having a helicopter crew. They can be launched incredibly quickly. They're incredibly fast. They're incredibly nimble, and they have really efficient recording technology. And they're making a huge difference. So they're already trialing them, for example, in the UK. I think there's various trials being used, and you can launch these out, and they will go out and fly over the seas and will record any criminal activities. So they're proving incredibly important, and they've got a bright future ahead of them. And that goes the same for underwater drones. So this is an underwater drone. The technology is still very much in its infancy, but we're really not far off now. This space where you'll have underwater cameras that will be inspecting various things like trawling or dredging or wreck looting or illegal mining or whatever it may be, and also obviously observing the environment and so on. So underwater surveillance is going to be important soon as well. And I put in this picture because this is a wreck. Now I've forgotten, because I made these slides over a week ago. I've forgotten which actual wreck it was, but I think it was off the coast of Italy. And obviously it's these are the amphorae from what looks like a sort of a Greek or a Roman trading vessel, probably filled with olive oil or wine at some time. But this was an example of a vessel which is being permanently monitored by underwater CCTV, and that is increasingly happening now, where, for example, an important wreck site or an important underwater site, like say a coral reef site or something, you can put in surveillance equipment and prevent divers or illegal fishers or whatever it may be from interfering with the site. So there's definitely a use for video technology and drones, which is going to make a huge difference as well. So that's it. So well done, everyone. Thank you for getting through that. It was quite a heavy lecture in the end, and quite dry and technical in places. You'd think crime and piracy would be interesting. I think the actual case studies are fascinating, which is why I'm really looking forward to next week's session, because I think our three colleagues who are going to be covering that session have come up with some great materials and articles. So I'm really looking forward to those discussions. And I think a case study approach in this area is going to be really fascinating. But the law itself, as you've seen in the session, is quite dry in places and largely untested. So I think there's a lot more law to be developed in this area, and it's something we'll discuss maybe in the next seminar. Next week's lecture, of course, is on pollution, marine spatial planning, and marine protected areas. So I will follow up with those students next week about getting that plan underway. So thank you, everyone, and I look forward to seeing you on Wednesday. And thank you for getting through that. All right, see you soon. Bye bye.